Arnab, we could ask you one question to actually take from here. Like you said, there are several channels and there are several media entities, including Republic, especially Republic, and in states like West Bengal and in states like Karnataka, where such petitions continue to be filed. What is the message that needs to go out? Because the courts are here to protect us, Arnab, but the political dispensation needs to know this arbitrary behavior needs to stop.
The point is, I have been always talking about this since last 10 years, that the particular section which gets exploited the most is the section about public mischief. So when you say that this channel or this network with the intent to contribute to mischief or to spread a rumor or to do something which is alarming or to provoke or to promote, and then you have a whole number of criteria on the basis of which not just religion, race, place of birth, residence. There is also category, please see, in section 5052, which is very generic, which speaks about any other ground, which basically means that I can accuse you of doing something wrong in any context. If you're driving your car or breathing the air, and I can even say that you breathed in the air to create public mischief. So it's such a broad definition. And I think when a broad definition exists, there is potential for use and misuse. So the only umbrella that we have is that when judges come and say you must not misuse section 5052. For me, the importance of this case was the fact that there has been a questioning on the application of 5052. In fact, against me, there was also a question that Justice Chandrachud raised on the application of 306. The importance in our case law is that when applications get questioned, you can't change the law. An individual, a journalist cannot change the law. Parliament changes the law and sometimes does not change the law because government and the legislative process has their own intent in keeping the law sweeping so that they can use it in any context. The only protection here is when somebody goes to court and an appellate court puts out something on the application of the law. And I think I'm very, very concerned that, section 5052 was such a dangerous section, and there are whole issues about bail and not bail. And once that process starts, it is just to annoy the citizens,
Yes.
And that is something which I'm very happy about in this case. For me, it is not about this case driven. I think this is case law for the future. So that 5052 is not misused.
Yes. Arnab, one last question. What could the message here also be for the West Bengal government that pursues Republic TV in several cases?
Well, I mean, the West Bengal government continues to alarm me. We have a case in Bengal where the state refuses to appear. And where, if I may say so, because our case is so strongly placed, where the state government is absent in court. You have a situation where we literally have to send notice to the Advocate General's office as a network, which we have done 3 days back, that kindly be there in court. It's alarming. And then the Advocate General comes and will waste the time to come and appear in court and make an argument on a case which is non-existent. Bengal, the crudity with which the Bengal government approaches harassment is just remarkable. And it's an absolute shame that they continue to do it. But, we will not be bogged down by this. We continue to do our work, and I'm sure that they will lose in court against us again.
Yes, Arnab Goswami, Editor-in-Chief. Fingers crossed, because you're absolutely right.